Hello, everybody. Sharon Adams here again to talk about trademarks. I'm going to talk about intent to use trademark applications and the difference between a trademark application that is in use and intent to use, and the different timelines and costs that are involved in this. So if a trademark application is filed in use, that means that the applicant is currently using the trademark and has evidence of use. So for example, if you have an online retail store, you might provide evidence of your website showing that people can purchase goods on your website. That is in use. However, if the applicant is not currently using the trademark when the application is filed, they can file intent to use trademark application. That's a great option when people know they're going to market, but they don't, they're not ready yet to have their product or service put on the market. But there's very significant differences in the timing and costs involved in filing an intent to use trademark application versus an in-use trademark application. So I'm going to try again to do this, to explain these differences. So I'm going to show what the USPTO shows on this. So this is from the US Patent and Trademark Office website. You can see it's trademarks, trademark timelines, section 1A timeline, application. Okay, you can see the link up there. But just to go to exactly here, I want to just show you something. Okay, this is on the USPTO website. Application filed, you can click on here and that gives you a lot more information. Step 1, application filed. Then if you go all the way down to here, step 8, USPTO registers your trademark. That is what happens when your trademark is filed as in use. I mean, assuming all the other steps went okay. The difference. Application filed. This is an intent to use trademark application. Your application is filed. You've got the same information that the USPTO provides up here. But then when you go down to here to step 8, it's a notice of allowance. It is not a registration. Okay, that is the key difference. So going back here, section 1A, when it's filed as in use, 1A is in use. When you get to 8, USPTO registers your trademark. Intent to use trademark application, when you get to 8, USPTO issues a notice of allowance. Now, all these other steps, I could go over, but I'm not going to do that in this video. What I'm trying to get at here is this difference. So between when an application is filed and step 8, the steps are essentially the same. Different things can happen, but the timeline is somewhat the same. It's generally in the range of a little more than a year. If everything goes relatively smoothly, you're looking at like 14 months to step 8. So if you filed your trademark as in use, okay, you're back here, application filed, it's approved. Okay, then that usually takes about 10 months, honestly, to this step, to step 2. It reviews the application, then if approves it, it's published for opposition. There's different steps, but anyway, we get to registration here. Hey, guess what? Your trademark is registered, you're done. Okay, so you pay your filing fee up front. Maybe there's some additional work that needs to happen in here in the middle. If like at step 3B here, if the examining attorney finds grounds for refusing to register your trademark, or if your application does not satisfy all legal requirements, the examining attorney issues a letter and office action explaining these refusals. I help people with this kind of thing all the time. Then assuming everything goes forward, you submit a timely response, it's approved for publication, it's registered. As I said, you're done. Let's go back to 1B. Intent to use. Application filed, 10 months go by, the USPTO reviews the application, same. This is the same. You either get an office action, oops, sorry, did not mean to do that, or you go back, or it approves it. So just to get to the difference, you get to a notice of allowance. That means your trademark has been reviewed and approved. It's allowed, but it is not registered. What is the difference? At this point, let's just do this. Now you can see all these additional steps here. Okay, at this point, when you've received the notice of allowance, within 6 months, you must file an extension request, or you must file a statement of use. Or if you do not file a statement of use or a request for extension, your application is abandoned. So that's where the costs come in, okay? Because the USPTO has a filing fee, and they have a filing fee to file an extension request or to file a statement of use. And then if you're hiring an attorney, of course, attorneys have their fees also. So every 6 months after receiving a notice of allowance, the applicant must either request an extension or must file a statement of use. Okay, so let's say 5.5 months go by and you decide to file a statement of use. You have to pay the USPTO filing fee and, of course, the attorney's fees if you're hiring an attorney. And then the USPTO will review it. However, the USPTO current timeline, they say 1 month. No, it's at least 2, and it's more like 4. Okay, so they will not review this statement of use at the end of that 6-month period. Let's say you received your notice of allowance on February 1st. Okay, well, 6 months go by, that's July 1st. Okay, you either have to file a statement of use or you have to request an extension. If in the middle of June you file a statement of use, it's possible the USPTO will accept that and you'll be all set. However, if the USPTO does not accept your statement of use, you're out of luck, okay? Unless you have also filed an extension request. They put it here as or. However, it is or and or. You can file a statement of use and you can file a request for extension of time. So if 5.5 months go by after your notice of allowance, you file a statement of use. The safest option is to simultaneously file a request for extension of time. That way, if the USPTO reviews your statement of use and has issues with it, you have another 6 months to correct that. Okay, what happens if you just file a statement of use and you do not file a request for extension of time? If the USPTO reviews your statement of use and says, hey, we don't accept it, you've got problems, you can only, this is why it's complicated, but you can only go back to in our example that we were giving before, you can only go back to evidence that you have as of July 1st, 6 months from February 1st. You can only go back to evidence that you have prior to July 1st to submit, okay? But if you have also filed a request for extension of time, you can amend, you can change things. You have until your next deadline, which will be that February 1st of the next year, okay? A year later, if you filed that request for extension of time, then you'll have that additional time to file it. So this is why you can just keep doing this, and you have up till 3 years after the date of your notice of allowance, 36 months specifically is what they say, to show use in commerce. After that, the USPTO will just cancel the trademark. You're not allowed to extend beyond that. But you can see how that would add up, because okay, you've gone through the process, you're here. Okay, got my notice of allowance. That's like a year and a few months into the process, generally speaking. Well, then you've got another 3 years of every 6 months paying fees until you show use in commerce. So I am making this video just so people can understand that difference. It's a little maybe complex. And as I said, if you go to these websites, these all have different things. We issue a NOAA, NOA, Notice of Allowance. And it has a lot of information. And as I showed you before, you can click on these things and then it will give you, it'll basically give you that same information. So, of course, you can contact me if you have questions about this. As I say, I'm Sharon Adams. I am a trademark attorney, and I do exclusively trademarks. I work on US federal trademark applications, California state trademark applications, and international trademark applications. But this, what I've just described here, is something that happens with US trademark applications. That whole intent to use thing is something that is particular to the US trademark system. Here is my contact info. My website is adamslaw.biz, and my contact, here's my homepage if you want to see it. And then here is my contact info. There's my phone number. There's my email address. You can contact me, and I'm happy to help you with trademarks. Hope you have a good day.